Doc Talk. Yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case, we breaking it all down. No rush, just pace. Howdy, howdy, howdy. I hope you guys are having a fantastic evening. Um, if you guys have been following the Jerry Jones civil case here in Dallas, specifically Dallas County, there is a whole side battle that is happening right now. And it don't even have to do with the actual lawsuit, y'all. It's a sexual assault lawsuit, but what's going on has nothing to do with it. It is a fight over whether the judge should even stay on the case. And this week, Jones's legal team fired back really hard, asking the court to not only deny the recusal motion, but to sanction the other side for filing it. Y'all, this lady has several attorneys, and they have even tried to withdraw from her case and could not do it, y'all. But anywho's, I'm Cassandra, aka your favorite paralegal, and this is Legal Doc Talk. Now we're about to break down these filings. It's two filings. It's two motions that were filed, and then they by the plaintiff, and then the defense replied to them. So we're going to be looking at a response in opposition and the set of evidentiary objections line by line so you understand exactly what's being argued and why it matters. Now, I am going to just show one of the responses on there because y'all, it's a lot of pages, and I want to try to make this a brief uh, episode. My members will get the full read of the document so you can understand exactly what I'm saying. So, let's first just set the scene, okay? So this is Janie Green versus Jerry Jones. This case is out of the 60th, I can't even talk, district court. The judge for that court is Judge Redmond. I have a lot of cases in her court, and she's awesome. She's so sweet. But let me just keep on. So this particular case has been pending for years. It was filed in 2020, September 14th, 2020. We're talking about 5+ years of litigation, and trial was getting close. Then, just 3 months before the trial, guess what happened? Plaintiff's entire legal team, all 7 attorneys of record, filed a motion to withdraw from her case. And what followed was honestly a bit of a mess procedurally. The first version of that withdrawal motion didn't say whether, plaintiff consented to them withdrawing. So a second amended version got filed saying she did not consent, right? Then a day later, a third version showed up, and this one was styled as an agreed motion to withdraw, now claiming that the plaintiff did consent with what was presented at her, she had her electronic signature attached. So you have three different positions in the span of 24 hours. Because of the inconsistency, defense counsel pushed for an actual in person hearing instead of just deciding, in the paperwork, the motions to withdraw as her counsel. And the court said, yeah, okay, let's have a hearing. So all the attorneys, the plaintiff, defense counsel, we could talk about this and see, what's really going on. Did she consent to y'all withdrawing, or did she not consent? Which one is it? That hearing got set for May 20th, 2026, and the court coordinator confirmed it would be in person with both sides, both of their attorneys required to appear. All right, y'all following? All right. 2 days later, not 2 days later, 2 days before that hearing, May 18th, plaintiff then filed a motion to recuse the judge and asked the court to stay everything. So when they say stay, that means pause the proceeding, okay? Here's the procedural effect, where that matters. Filing a recusal motion automatically halts the case. So with that withdrawal hearing that was supposed to be on the 20th, guess what? It got canceled. And everything downstream of it, froze while that recusal question got sorted out. So, what's the plaintiff's actual argument for why this judge, Judge Redmond, should be removed from the case? When you cut through hundreds of pages of briefing, it really comes down to two arguments. Y'all, if I show y'all the dockets and all the filings, it is overwhelming. It is overwhelming. If I was on this case, I would quit too. I'm not even gonna lie to y'all. But anywho's going through her filings, these are the two arguments that I say the two real arguments, because to be honest with you, in me reading the whole response, even the defense counsel for Jerry Jones, they said that this lady, I don't even know who it is. It can't be her. It got to be the attorneys on the case, because they probably couldn't get out of it. So at this point, they don't care. They they used AI, and the defense counsel pointed out that the plaintiff is submitting frivolous AI content. Y'all, it's crazy. But going through all of that, y'all, there's only two arguments. Argument one, improper ex parte contact. Plaintiff says that sometime in early to mid-April, she called the court and left a voicemail asking whether she personally, needed to show up at the hearing on her attorney's withdrawal. According to her account, the court coordinator, Nicholas, now Nicholas get on my nerves, but I mean, he's a court administrator. I mean, like, he's the court coordinator for the 160th. Like, I don't, like, what? But anywho's, he called her back. He called her back on May 13th. He left her a voicemail telling her, you have to appear. On May 15th, he called her again to follow up and said that, and she said that she'd be out of town, and he told her that she can appear via Zoom instead. Plaintiff complaint is that her own attorney weren't copied on anything, any correspondence regarding these calls. Okay, so that's her argument. She's saying that her attorneys were not informed. I don't, how could I say this? As an attorney, you already know to show up in court. That's number one. Number two, when there's a hearing, we always call hey, you have to appear in court, because that's what the judge is at. If the judge says everybody, including the parties, the attorneys, have to appear in court, best believe they would be contacted. So I'm not sure how she thought that because she was contacted, like the court coordinator is going to call everybody to ensure that everybody shows up for a hearing. But anywho's, let's go on to the second argument. Cumulative bias from the judge's rulings was her second argument. So she's saying that the plaintiff's team compiled a list of rulings they didn't like over the life of the case. Discovery rulings, continuance rulings, sanction rulings, and argued that all of those added up together, that's a pattern that shows the judge is biased against her. There's also a third thread woven, through the briefings, even though plaintiff frames it as context rather than a standalone argument. Defense counsel's law firm made a $5,000 donation to Judge Raymond's campaign. Among donations the firm made to several other judicial campaigns. Plaintiff points to that donation as part of the overall picture. So she just feels like judge should be recused because they made a donation to the judge and several others. Okay. Anywho's, let's go on. Let's go on. Let's talk about the law Jones's team is leaning on, because it is generally useful if you ever find yourself dealing with a recusal issue. And you guys have heard it if you are following me from the not about to say Nolan Wells, from the Carmelo Anthony's case. You are familiar with these procedures. The first one is the Texas Rule of Civil Procedure 18A. And this rule sets the bar for what a recusal motion actually has to show. One, it has to be verified, meaning sworn to under oath. It has to assert a specific ground listed in a companion rule in 18B. The facts have to be within the affiant's personal knowledge, or if they're based on information and belief, the motion has to specifically say what that belief is based on. And critically, Rule 18A says a recusal motion cannot be based solely on the judge's rulings. That's written directly into that rule. Second, the ex parte distinction. The Texas Code of Judicial Conduct, Canon 3, we know about Canon 3B10, but this is referencing Canon 3B8, which prohibits ex parte communications made to a judge about the merits of a pending case. But, and this is the part people often miss, the canon expressly carves out communications about uncontested administrative or uncontested procedural matters. So the real question isn't, did someone from the court talk to one side without the other side there? The question is, was that conversation about who should win, or was it about the logistics, like what time a hearing starts or whether someone needs to show up in person versus, by Zoom? Texas courts have consistently held that the second kind is fine, even when it happens without the other side's presence. Third, and this is the big one, the extrajudicial source doctrine. Texas has adopted this from federal law, and it says that for a judge alleged bias to justify recusal, that bias generally has to come from a source outside the courtroom, some outside relationship, an outside financial interest, an outside, statement, not from decisions the judge made while presiding over the case. Let I, the idea is simple, right? If you disagree with the ruling, the remedy is appeal, not accusal. Texas courts have said over and over that a judge's rulings alone almost never constitute a valid basis for a recusal motion, because rulings made it in the course of litigation can't show reliance on some outside extrajudicial source of bias. And that same logic knocks out the campaign donation argument. Texas courts have held that a donation to a judge's campaign does not support recusal unless there's actual evidence of communication or coordination between the judge and the donor about how the case would be handled. A donation by itself without that connection isn't enough. Okay? Now, here's where it gets really interesting from a paralegal's eyes view, because Jones's team didn't stop at deny the motion. They filed a separate document, objections to plaintiff's evidence. And I should I pull it? Well, I guess I'll pull that up on, because this is the sanctions part that's on the screen. All right, there we go. This is the objections to plaintiff's evidence. I'm just gonna kind of leave that there for a little placeholder. This goes affidavit by affidavit, line by line, and challenges almost every everything plaintiff submitted to support the recusal request. Y'all, I kid y'all not, it was 10 exhibits, and those 10 exhibits were like hundreds of pages, y'all. It was a lot. They named them volumes. I was like, freaking G. I see why they want. And the crazy thing is, I contract with plaintiff firms. So we are on I'm on the side of the plaintiff, right? But at a time when you're in this case, and now don't get me wrong, the attorney, we try to support all plaintiffs, right? And that's why screening them before even accepting their case is something that you definitely want to do. This case, I think they got into like it probably started out great, and then because all plaintiffs, they really think that they, how can I say, now there are some that know their stuff. However, the purpose of you hiring an attorney's office is that they can represent you, they can do the research, they can reach places that you cannot do so. In the event that you feel that you can run the show by yourself, why hire a law firm, right? Why retain them? Now, normally with these cases, it's on contingency. So the plaintiff does not have to pay anything up front. Their fees, their attorney fees, will come out of the settlement. That's how it works. So a lot of this stuff, experts, depositions, mediations, transcripts, records, all of that stuff is being paid up front out of the attorney or the firm's pocket. So once again, they probably, was into this, and then all of a sudden, Miss Green flipped the switch, and they was like, okay, we got to get out of this. But the judge is like, not so easy. Defense was like, not so easy, because they really tried to get out of this case without the consent of the plaintiff. And then they ended up filing a second amended motion to withdraw with her signature, and then they filed the third amended. That, you don't think that's a red flag? But anywho, let's let's go back into this, y'all. This that you see on the screen is a real world lesson in the Texas rules of evidence. So we're going to walk through the categories. Let me see. So category 1, let me see. All right. Man, this is deep. Okay, we're going to leave it right here. All right. Hearsay, and even hearsay within hearsay. A lot of the affidavits aren't firsthand accounts. They're one attorney testifying about what another attorney told them, who was in turn told something by the plaintiff. Each one of those layers has to independently qualify under the exception to be admissible. And the objection argue that repetition doesn't cure that problem. Just because 5 different people repeat the same secondhand story does not make it evidence. Yeah, I got that. Let me see what these affidavits. I think. It talks about the. Yeah, this is the section. So I'll make sure I pull it up for you guys. Yeah, so they had what affidavit of Thomas D. Bowers, Janie, her own self, Sarah Catherine Leary, Denise Campbell. They actually had an affidavit from Tiffany McAdoo, aka Tiffany Billions, y'all. Yeah. Okay. So the first part we talked about was the hearsay. Category 2, personal knowledge, lack of personal knowledge. So several of the affiants simply weren't present for the events that they're describing. One affidavit, for example, describes what happened when a witness arrived at the courtroom, but the person testifying admits he wasn't there and only heard about it afterwards. See, hearing. You don't have firsthand knowledge. You have secondhand knowledge based off of what somebody told you. Category 3, improper lay opinion and legal conclusions dressed up as testimony. This is where you see language like calling a ruling astonishing or describing conduct as legal gaslighting or judicial bullying or comparing the proceedings to Kill a Mockingbird. The objection argued that's advocacy, not evidence. An attorney's characterization of what happened isn't the same as a sworn testimony about what actually happened. Category 4, authentication problems. Let me see. I believe that she ended up, let me see if it's in there. All these things are kind of just ruling together. These are the affidavits. I think it's in the other one. I think it's in the other. Yes, is it in the other filing? Yeah, it's in the other filing. But that's okay. Uh, yeah. When I tell y'all, it's a lot. It's a lot. Okay, I'm just gonna put something on the screen so y'all have something to kind of look at. Okay. All right. Okay. Authentication problems. That's the fourth category. So there's a phone screen photo submitted as evidence of a voicemail. Supposedly, oh yeah, that's in the plaintiff's filing when she filed for the motion to recuse Judge Redmond. Supposedly showing an automated transcription of what was said, but nobody testified to who took the photo, whether it accurately shows what was on the phone or whether the transcription is even accurate. And there's a great concrete example buried in there. The transcription itself identifies the caller as being from the 168th district court when the actual court is the 160th. So that's a small typo, but it's exactly the kind of detail that undermines the reliability of an unverified automated transcript being offered as if it were reliable evidence. And the reason why I'm pointing this out is because even if y'all followed me from when I was doing the Jay-Z and Tony Busby, and Busby was submitting transcripts of the voice messages that were being left by those what they call, I don't even know what they was calling them, people that was going after people, investigators. Like, even the transcripts that he submitted to the court were transcribed and certified and authenticated. Like, you just can't submit something and say, here's my evidence. It has to be authenticated and transcribed by a specialist, and that has to be filed with your filing, with your whatever evidence it is, audio or video. So even with that, she just submitted a screenshot along with a transcription of what the voicemail said. And even if you looked at that, like I said, it's the transcription description said 168th. This is the 160th district court. So category 5, evidence sneaking back in after being struck. So before these filings, the court had already issued an order striking one affidavit entirely and striking specific paragraphs of plaintiff's own affidavit. The objections argue that later affidavits from other witnesses were essentially trying to reintroduce those same stricken allegations through someone else's mouth, and that stricken evidence doesn't become admissible again just because a different person repeats it. And then there's the sheer volume, roughly 4,000 pages across the 10 appendix volumes. The objections frame that volume itself as part of the problem, burying the court in paper instead of presented focused, admissible evidence. Those 10 volumes were outrageous. Like I said, I would have quit because I'm not going that like it doesn't make sense. And anytime you file to the other, to counsel, they have to go through all of those pages. So I can only imagine. But I feel bad for the seven attorneys that had to sit there, and I'm pretty sure the attorneys didn't even draft it. The paralegal probably did that. And as a paralegal, I probably would have quit. Cause ain't no way. Ain't no way I'm about to sit here and draft thousands and y'all, roughly 4,000 pages. Are y'all listening? This ain't even trial. This is just a motion to recuse. Whew. And now this brings me to the sanctions part. Okay? Rule 18A has its own sanctions provision, subsection H. It lets a judge order a party or their attorney to pay the other side reasonable attorney fees if the recusal motion was either one, groundless and filed in bad faith, or to harass the other side, or two, clearly brought for unnecessary delay without sufficient cause. Those are two separate independent grounds. A judge only needs to find one of them to award sanctions. And let me tell you this, after $4,000 of pages, I said $4,000, 4,000 pages having to go through, having to sit there and draft responses for frivolous motions that have been filed throughout the years, that adds up. So $55,000 or more, 55,000 should be a minimum. And if judge, I think actually Aaron Noel is going to hear. And if y'all don't know, I used to work with when I was at the law firm that I left. When I first got there, I interviewed with who is now Judge Erin Noel. She was attorney there, and she is feisty. She's feisty, but she's fair, and I learned a lot. And I am just grateful to have done work for her. But guess what? Guess who's hearing this motion? Judge Aaron Noel. And baby, let me tell you something. I tell you what, I bet you she's going to deny plaintiff's motion to recuse Judge Redmond. And I bet you she's going to award sanctions against plaintiff. And that's coming. Miss Plaintiff, you're going to have to cough up $55,000. I need to say I want to go tomorrow. I want to go. So we're gonna see how that goes. But anyways, let's go back into this. So Jones's team argues both apply here, in which they do. One, when we talk about the delay point, they lean heavily on timing. The motion was filed 2 days before a scheduled hearing, which is exactly the hearing it ended up canceling. And then plaintiff kept expanding the fight afterward with more supplemental filings, more discovery requests, and more appendix volumes, even after the court had already struck a chunk of the evidence, y'all. On the bad faith point, they argue plaintiff and her counsel knew or should have known through reasonable inquiry that an administrative phone call about hearing logistics doesn't establish judicial bias under settled Texas law, and pressed forward anyway. In other words, the plaintiff firm should have known that it was an administrative cause. We all get calls like that. And if we don't get calls, we get correspondence in the mail when there's a hearing or an email. So I'm not sure. I'm like, I have to look up those attorneys. Like, are y'all in Texas? Like, I'm not understanding this. And you know what I do, because this lady is from South Carolina, so I need to look at that, because maybe they're not familiar with Texas law. I don't know, but who knows? Um, so on the bad faith, they argue, that plaintiff and counsel should have known, um, but they have backed their request with an actual number. $55,413.35 in attorney fees and expenses laid out in a sworn fee affidavit from one of the firm's partners. That figure covers reviewing the voluminous supplemental briefings, responding to discovery and subpoena requests, litigating the admissibility fight we just talked about, and preparing for the recusal hearing itself. I bet you Aaron is Miss Judge Noel. Let me put some respect on her name. Judge Noel is going to grant that sanctions. I strongly believe that she's going to grant that $55,000. Because me looking at this, there's they're doing too much, and I need to go back and look at that first motion to withdraw, because I believe I read it, but from what I read is that, and normally when we file a motion to withdraw, we have to actually state our reasoning as to why counsel is wanting to withdraw from the case. Maybe it's like the differences between, maybe they're button heads, or maybe just depending on what type of case it is, and the plaintiff had to pay up front, or the defendant, maybe them not paying in time. But for sake of this case, it's differences. I'm pretty sure Janie is probably telling them, you should do this, you should do that. Why you not doing this? Why you not doing that? And that can put a strain on the attorney client relationship. Now, uh, I'm going to be honest with you guys. A lot of people think, hey, you work for me. That's what they think. Law firms work for them. No, law firms do not work for you. I want to make that clear. Law firms do not work for you. We work with you to try to come to a better resolution. Okay? It kills me. Well, y'all work for me. You got to do what I say. No, we don't have to do what you say. And we can easily, if you want somebody else to do it, you could definitely go find somebody else to do that. But I'm telling you this now, no attorney is going to put up with that. Like I said before, when we're dealing with these type of cases, personal injury, catastrophic injury cases, sexual assault, wrongful, any of these cases, it's on a contingency basis. Firms do not get paid up front on contingency basis. They get paid out of the settlement. But all of the cost to file a lawsuit, to serve, to do discovery, to get medical records, to get billing records, to get, any type of records, to issue subpoenas, to pay for records, to get experts, to get depot transcripts, to pay for mediations, to go to trial, all of that cost. And when you even go to trial, it's a 50-50 chance. Either you're going to win or you're not going to win. And if you don't win, you don't get nothing. And the attorney or the firm has to eat that cost. So the the recusal hearing is tomorrow. I'm going to see if I'm going to make it. However it plays out, I am going to make sure you guys know. Okay. This is a good real world study on how a procedural fight actually works, and it's how it's separate from the case. We're not even fighting about the sexual assault portion. We're fighting to see if Judge Redmond is going to be recused or not. So, anywho's, y'all go ahead and like this video, share it, subscribe to my channel if you have not done so. If you are interested in a little bit more exclusive content, actual reading of the court filings, definitely join my channel. I do have different membership levels available. Until then, I'm Cassandra, aka your favorite paralegal, and this has been a Legal Doc Talk. I will catch you guys in the next one. Bye.